Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Mazzucci.
Welcome, everybody, to another exciting episode of our show. Today, we are talking with Daniel Van Slyke. Did I say that correct? Van Slyke?
Van Slyke.
Van Slyke. Okay, I'll do my best. Daniel is a estate planning attorney, a litigator that turned planner. He has an extensive resume, JD from Texas A&M, magna cum laude, and today we're going to talk about asset protection. So first of all, Daniel, welcome to the show.
Thank you. Happy to be here.
Second, California is one of the most litigious states there are. I mean, there's a lawsuit every day, and we hear asset protection. I mean, is it just a gimmick? Can you really protect your assets in California, or is it just a way to say it's going to be a little bit more difficult if you sue me?
No, you can't really protect your assets in California. California is extremely litigious. Yeah. And there's no real meaningful tort reform or anything like that. So anything I do for you is to try to avoid lawsuits in the first place, or to slow down creditors when they happen, or to bring them to the bargaining table because it's just a little bit too much trouble to figure out what you have and to access it. Okay. So that's so if you really want to protect your assets, you got to get them out of California.
Okay. All right. We'll talk about that in a second. For those who don't want to get the assets out of California, let's talk about, people say like, I already got an LLC, I got this. Now, what I understand is that, you are as an estate planner, you do comprehensive planning. So you kind of look at the way people, all of the aspects of a person's life. So my question to you isn't an LLC enough of a protection? Isn't having insurance on your business enough of a protection? I mean, what are the mistakes? What are the things you see? What can you offer that's different than that?
Yes. So insurances and LLCs, those are fundamental lines of defense.
Okay.
Like asset protection isn't just one shield. It's more like, think of all the defensive mechanisms at a castle. Like you have a moat, and then you have an outer wall, and then you have an inner keep. So what you're really doing is you're protecting the assets in your castle with layers of asset protection. Now, of all those, insurance is a fundamental first layer.
Okay.
So have as much insurance as you can afford, but watch out. The thing is, insurance companies, why is that not just sufficient? Because insurance companies don't cover everything.
Right.
Especially in California, there are a lot of exclusions, including in landlord-tenant arenas, for example.
Right.
And then if you do something wrong, or you don't tell the insurance company, let's say you misrepresented, or they can make an argument that you misrepresented something in your application for insurance. That's another reason for exclusion. You may not have any clue what is excluded. Yes. So that's the thing. Insurance is a great first line of defense, but you really need to keep in mind that insurance has its limits. So then your next line of defense, LLC. So this is an interview about real estate, right? You're a real estate broker. So an LLC gives you a veneer of asset protection in California, but in California, the courts are very quick to do what they call piercing the corporate veil.
Yes.
And that means really that they found a reason to say, that LLC is just a sham. It's really just all you, and therefore I can treat it like it doesn't exist, and I can pierce the corporate veil in order to reach your personal assets. So you have
Let's talk about that for a second. I'm going to stop you. Piercing the corporate veil. I'm very interested in this subject. Commingling of funds. There is a way to run a business in a professional, business-like way, where piercing the corporate veil is not the easiest thing to do. But for most mom and pop landlord in Los Angeles, that is super easy, because they just put the title of the company in LLC, then they put the rents in their own accounts and all of that, which pretty much shows that there's no business there. There's just, is that something you look at when you look at people when they say like, I have an LLC, how they run their business? Is that part of your planning?
Yes, always. If they come to me with an LLC already, I'll say, okay, let's take a look and show me your internal agreement. Show me your operating agreement in California. Right. That's what it's called. And more than half the time, they won't even have one. Well, right there, that's an argument for piercing the corporate veil. Boom, just like that. And then I'll ask them, well, who's managing the property? Oh, that's me. I'm like, okay, well, you have personal liability for that anyway.
Right.
So the corporate veil, it doesn't even have to be pierced. They can go after you personally. So there are ways, if you're going to be the mom and pop landlord who's actually managing the property, you're not going to avoid personal liability. Now, if you can use a property management company to kind of buffer you, and then you follow best practices to avoid piercing the corporate veil, you'll do better. But let me step back and tell you exactly what in the LLCs, even though the asset protection is somewhat thin in California, it comes at a high price.
Okay.
So California requires an $800 annual minimum franchise tax or fee.
That's right.
So if you make enough money, you're paying more than 800. The 800 is the minimum. Even if you make $0 in your LLC,
yes,
you have to pay that $800 every year. Now, that's another thing. People will come to me and they haven't been doing it. They'll say something like, well, I lost money last year, so I didn't think I had to pay the $800. Like, no, that's another way that they're going to pierce the corporate veil, because you haven't actually been complying with the state's requirements. Also, an LLC in California, you have to file a statement of information every 2 years. What if you're behind on your statement of information? Pop, the veil gets pierced again. So if you follow best practices, you stay on top of it, and you have somebody else managing it, it gives you what I call inside out creditor protection. So what's that? That means that if somebody slips and falls on the property that you have inside the LLC, then when the lawsuit comes, all they can get is the property that is owned by the LLC.
Right.
So if everything's done properly, they can't pierce the corporate veil to reach your personal property. So they can't go after the bank accounts in your name and maybe the other properties or your home that's in your name. So it just limits the liability to inside the LLC. So there are other states that actually provide fuller protection, so that if let's say you get in a car accident in California, if you're in a 5-car pileup, right? And let's say you're 1% responsible for the accident.
Oh, we're going to talk about negligence. I love this.
Yeah. And so this is what they call joint and several liability. Even though you're just 1% responsible for the accident, you can be held 100% responsible for the bill. So here's what the plaintiff's attorney does. The plaintiff's attorney sits down and looks at all the information that he has about the people that were involved in that accident. And he's looking for the deep pockets, right?
Right.
Because, the homeless guy pushing a cart around, he doesn't get sued.
Right.
It's not worth your money. He's got nothing to sue, right? So they're looking for deep pockets. So what are they looking for? They're looking for real property in your name, businesses in your name. Maybe you've got a flashy website that shows you driving your fancy cars. I don't know, your McLaren or whatever. So they're looking for signs that you're the person with deep pockets, that you've got the wealth, you're worth going after. So if they find that, they can sue you. Now, if they get a judgment against you, that LLC is not protected.
Right.
So your plaintiff's attorney, the plaintiff that sues you in the car accident, he's going to get the LLC. There's no outside-in protection in California.
Let's make sure our audience understands this, because you brought up such a good concept here. This is particularly important in California. If the court determines that you of that tort, you have a percentage of responsibility, you're found negligent, you had a duty, etc., and all of that good stuff is established. No matter the size of the percentage, let me make sure that I understand. And no matter the size, you can be responsible for the entire bill that the person incurred. Like even if you are like 5%,
right?
So that's crazy. See, that's what makes. So you're right. So people investigate. So how do we? Okay, I guess this is the thing. You're right. The plaintiff attorney, they call him ambulance chaser. I have plenty of PI attorneys that are my friends, so I'm sorry for saying this, but some of them are, and they basically do asset search. Help me understand how, because you said something before. You said this show is about real estate, but I'm going to tell you, I have some news for you, Daniel. This show is about life. Real estate is part of it, but this is about, like, I cover all aspects of a person, of an individual, because like estate planning and all of those things. So let me ask you this question: how do I, who have, any person who has considerable wealth, or a family. It doesn't even have to be considerable. If you have children you're supporting, like it could be, in LA, you'd be surprised how expensive life is. I'm sure people that are not in California. How do I put a protection in place so that if something like that happens, I can, I come to you and I say, okay, Daniel, look at my estate, everything that I have. What do we do? Where do we start?
Well, we did start about talking about those layers of asset protection.
Yes.
So one thing you need is you really need good insurance. And that includes, people don't realize there are a lot of uninsured motorists on the road in California. It's actually a shockingly high percentage of the cars out there. So you need uninsured motorist coverage. Right. That's one thing you certainly need, and that's going to help. Now, the next thing is anonymity. Anonymity is a preventative measure. So what does that mean? That means that if you hold considerable assets, business interests, real estate, you don't hold them in your own name, because if you hold them in your own name, it's really easy to find that you're the person with the deep pockets. You're the one in that 5-car pileup that I want to sue. Because otherwise, if they don't see what you have, the plaintiff, and I'm talking to plaintiff in a shakedown lawsuit, the person that gets up, walks around, she's fine after the accident, but a week later, after she talks to the PI attorney, she can't move, she can't even lift her pinky finger, right? So I'm talking about the shakedown lawsuits. So what they're doing, and again, for the attorneys get a lot of that money, so they want to know that they can collect in the end. And since they work on contingency, if they don't know that they can collect in the end, they're going to want to settle for the insurance policies beforehand. So that's why anonymity is important. You don't want them to know that you've got stuff in your name. So how do you do that? First of all, don't flaunt your wealth. Don't drive around the expensive car or post on social media about your expensive vacations. Plaintiffs' attorneys can find that stuff really easily. Very, very expensive cars in your name, that's a good example. Social media posts, that's a good example. But then also real estate. Never own real estate in your own name. If it's your investment property, you don't want to appear on title at all.
Right.
And that's both for the car wreck where people are looking for your assets, and also for the slip and fall that takes place on the property. You don't want them to be able to figure out who you are. So what do you do? And there are some estate planning advantages also, by the way, of purchasing a property in an LLC in California, which we can get to later. But the idea is, if you can purchase a property so that you are not personally on the deed records, then it's going to be really hard for somebody to find out that you own that property. And the plaintiff's attorney in the 5-car pileup, he won't know it until 2 years down the road, however long it takes, maybe 3, he gets a judgment against you, and then he sits you down at the end of the suit. So this is after he goes through all that trouble, after he fronts all this money, all this time, pays his staff. At the end of the lawsuit, he sits you down for a debtor's exam where he gets to ask you questions about what you own. But he doesn't know until then, unless you've made it part of the public record. So LLCs are great for keeping your name off the record. If you purchase a property, purchase it in an LLC. Never appear on title if you can avoid that.
Very nice. Okay, LA, Hollywood, a lot of celebrities, easy names. You get in a pileup, your name is Taylor Swift. Chances are, somebody's going to go after you. So I know that there are things like blind trusts. I know that, there's some instruments out there that some people use where the attorney is the trustee, and then they resign after they file the trust and all of that. Let's talk about, when you do estate planning for high net worth individuals, sometimes people who are in the public eye, what are some of the things that you look out for?
Yeah, I mean, you're right. Some people have a name. So if you see that name, they're going to know that there's wealth somewhere. So how do I get it? So what do you do with that? And there are reasons that they would want to preserve anonymity as well. By the way, I have taken people off the deed records and kind of hidden their homes because they had people on their front lawn taking photos while they were cleaning dishes after dinner. So they, for privacy reasons, again, you would want to keep your name off of the assets you have. But what do you do? High net worth, you have options. The more money you have, the more options you have.
Right.
Okay, so let's talk about some advanced asset protection strategies. The gold standard is the Offshore Asset Protection Trust. Okay. So that's where you have money in like the Cayman Islands or something like that, the Isle of Man, wherever. Name your favorite place to go that has a population of like 600 people, and half of them are attorneys and fiduciaries and trustees. So you go to those places, and they design these trusts so that you put your money, let's say, and I only recommend this for people that have millions and millions to spare. So if you're 100 millions, you can afford to take 20 or 30 million and put it into an offshore asset protection trust.
Right.
And the other reason you have to really be high net worth for that is it requires a lot of headspace, and there's a lot of cost involved because you're paying attorneys in that jurisdiction. Say it's the Isle of Man, you're paying attorneys here, and there's a lot of tax compliance. So you're paying some pretty high level CPAs to do some serious tax compliance type filings for you. So, but if you can live without that money and you can afford that, it's really pretty much untouchable.
Okay.
So no matter what you get involved in here now, and let me add the caveat: you're not untouchable. Your money is untouchable. So don't try to do this to like defraud people, because where you have bad actors, what happens is the court has a judgment against you, and there's no mechanism by which that money can be accessed to be paid. It truly is protected.
Right.
So the judgment can't be paid, and now the judge will say, well, you know what? Then your behind is going in jail. So they'll jail you for contempt of court.
Right.
And there are people who literally have languished in court for years just because of contempt of court, because they had money in an offshore asset protection trust. Now, that's usually bad facts, right? Like you defrauded people in a Ponzi scheme, and then you put the money in an offshore asset protection trust.
Yeah. So if you worked for Enron, probably, and you're one of the executives over there, plan is not for you. But people who have genuinely, like you said, people who have genuinely are high net worth individuals and who want, obviously keep a considerable amount of wealth in the United States, in California, whenever, but they want to say, you know what, I'm going to have an insurance policy, quote unquote, where some of the funds would be somewhere where maybe, like a disgruntled child cannot, get a hold of them after I die or something like that, whatever that may be. So this is something that it's called, what is it called? An offshore trust?
Offshore asset protection trust. Yes.
Offshore asset protection trust. Wow. I never even heard of that. So we're really digging deep into this. I love that. Great. So let me ask you a question. You come from a litigation background, right?
Oh, yeah, but I was just getting started on the advanced planning strategies.
Please, let's go. You're right.
Can I go down to the next level? Because that's the one
Absolutely.
That's the one that's super expensive. That's for your billionaires. Probably all have offshore asset protection trusts. But now, when you get down to the next level is like a little more affordable. It's the domestic asset protection trust.
Okay.
And over 20 states now have these laws where they allow these things. What is it? An asset protection trust in general is a trust where let's say it's your money that goes into it. You're also the beneficiary, and it's protected from creditors.
Okay.
I mean, everybody wants that. I call it the unicorn trust. The unicorn trust is where it's my money, I'm the beneficiary, and I'm in 100% control. Well, that part about the control, you're going to have to let go of, because you don't get that. But you can, if you're in a jurisdiction that has these laws, you can set it up a self-settled trust where you're the beneficiary, which is an asset protection trust. The best, perhaps the best and most frequently used jurisdiction is Nevada for that.
Okay.
But in order to do that, the assets have to be in Nevada. And it sure helps if your behind is in Nevada too, because if you live there, then Nevada law applies. The problem is, as you might guess, California does not have a domestic asset protection trust. So you can use it. You can use a domestic asset protection trust in another state, but then again, you're going to have that money that you can live without. You're going to have to. You can't do this with California real estate or anything that you can't get out of California.
Right.
It's got to be probably liquid assets that you're putting into the hands of a trustee who is in Nevada, and then that's going to slow down creditors for sure.
Let me ask you about that. You said something that sorry for interrupting you, but you said something that got my attention. You have to give up some of the control. You are the trustee, you're the beneficiary. How much control do you have to give up, and how does that work?
Well, you're not the trustee. Yeah. So you're the grantor, meaning you put your stuff in there.
Okay.
You're the beneficiary, meaning you benefit from distributions, but the trustee is the one who's actually in charge of making those distributions.
And usually are these attorney, accountants, professional fiduciaries, corporation? Who is usually the trustee in these cases?
Yeah, they're professional trustees. It can be there are companies that do nothing but that, especially in Nevada. So they're like a combination of bankers, fiduciaries. Yeah.
Very nice. Okay.
I don't generally recommend hiring an attorney to do that. That's probably a little more costly than you need. to go, but attorneys can do that. Yeah.
Got it.
And now, all those are not really that, they're a little shady for California residents. So there is one thing in California, though, which is probably the best you can do to protect your California-based assets.
Okay.
If you're a high income earner, so that doesn't necessarily mean you're high net worth, right? That means you're making a lot of money every year.
Right.
Think of your doctors, think of your lawyers, especially the plaintiff's attorneys. They're just raking in money every year. So what you can do is you can set up what's called a private retirement trust. And this is a California private retirement trust. It is a California law. And for that reason, the courts have generally respected it. And the California private retirement trust is where you have to do a lot of calculation up front. So this is no quick and easy, inexpensive thing either. But it's going to be less expensive than a foreign asset protection trust, and you can protect your real property in California. So how do you do that? You do a big analysis to see what your lifestyle is now, how much income you have now, and then how many assets you're going to have to set aside for your retirement in order to preserve your lifestyle in retirement, the same lifestyle you have now. So that's where a lot of headspace and calculations go in at the front. Then you form this private retirement trust, you put assets in it, and if you've done it all right and you've set it up properly and you're actually following the scheme, it is a very tough nut to crack in California. It's about the best you're going to get, because the California judge is going to look at your Nevada asset protection trust and say, I don't like that. He's going to look at your foreign asset protection trust and say, I don't like that either. But if he looks at your California private retirement trust, he's going to say, well, that's a California law. Let's see how it works. Oh, yeah, there's a lot of case law around this. So that's a great one too. All this is kind of for people that are high net worth or high income earners.
Okay, very nice. Got it. And this type of trust, you said, since they are California, is there a limit how much you can contribute to it? Because when you say the word retirement, somebody not experienced, such as myself, thinks about 401k, Roth IRA. But is there a limit how much you can contribute to it? Is there, how does it work?
Yeah, this is the true lawyerly answer. It depends. If you decide you want it ERISA governed, then like a 401k or an IRA, there's going to be a cap on what you can put into it. Now, for that reason, most people don't want it governed by that federal law that governs retirement plans. So instead, they'll just set it up so it's not governed by that. And then there's the only limit is what you can prove is necessary for you to preserve your lifestyle in retirement, which is the equivalent to the lifestyle that you have now while you're at your peak income earning years. So
very nice. Okay.
Effectively, there's no real limit. You can put a lot more into it than you can a 401k.
Got it. Okay. So we started from the offshore. We went to the Nevada one. Now we're in California. What about the cookie cutter? I don't want to say cookie cutter, but the living trust, the one we talk about, that everybody knows. What are your thoughts about that?
Can I pull a politician and totally ignore your question and just talk about what I wanted to talk about?
Absolutely. Let's do that.
I'll get to that. But the thing that I wanted to address was the 401k, since we're on the 401k.
Okay.
Yes. So this is like every man who has an employer anyway. This is the everyman's way of actually protecting assets. There are certain assets that are protected, even in California, although there are fewer in California than in other places. But one of them is your 401k.
Okay.
Most types of creditors cannot touch your 401k as long as you're not making distributions to yourself. Okay. So if you have an option of packing money into a 401k, that really is the most, that's a lot of asset protection, the most you can get. Again, in California, that's going to be very heightened. Most types of creditors are not going to be able to touch your 401k. Although California does have a law now, it's been on the books for just a couple of years, but when you're in retirement and you're taking minimum distributions, they actually can garnish a certain percentage of those.
It's a percentage of the distribution.
Yeah, that's in retirement though. So if you're not in retirement yet and you're not taking in distributions from your 401k, it's protected. And then when you retire, you go to Nevada and where that law, they don't let you do that, or you go to Texas. So I'm also licensed in Texas, by the way. And there are times where, the best thing you can do to protect your assets is just move to Texas.
Don't mess with Texas, right?
Yes. Well, if you want to think from the asset protection standpoint, California is an extremely creditor-friendly state. Mm-hmm. Texas is an extremely debtor-friendly state.
Okay.
And it's been that way for 150 years.
Wow.
So it is literally in the Texas Constitution. There are all these protections of your home, for example. So it doesn't matter how much your home is worth. Most types of creditors can't touch your home. So nobody's ever going to, even if you have a $2 million home, which is a lot of home in Texas, you get in a car accident and you're sued and they get a judgment against you, they can't touch your home.
Wow. Interesting.
Yeah. So regardless of its value. So there are other states that are more debtor friendly. And it actually has been a way to bring people to the state, those rugged Western individualists. A lot of people were fleeing debt in the Northeast and going to Texas.
Right.
Yeah. So it's deeply rooted in the law and the culture there. All right. Now let's get back to the question you wanted to ask.
Okay. Now this is good. Thank you for saying. No, the question was about our good old friend, the living trust. What are your thoughts on that? The one that most people who do estate planning, most people who have an estate plan have a living trust. What are your thoughts on that?
Living trusts are a beautiful thing. They're very important. They really should be at the heart of any estate plan in California. So if you have a house, you should have a living trust in California. That's all there is to it. Because otherwise, the house is going to have to go through, most likely, there's going to be a probate somewhere. And probates are lengthy. They cost more than a trust for sure. And also with the trust, you can determine who gets your assets and what shares. Maybe you want to give some to charity. You can do some very sophisticated tax planning with trusts if you have a taxable estate, which we can get to later. But you can do a lot of neat things with trusts. You can also protect what your heirs receive by leaving things to them in trust.
Right.
But it doesn't protect your own assets. A revocable living trust does not protect your own assets. And a lot of people think that, it's in the trust, therefore I'm protected. No, you are not protected because when you're the settler, your stuff is in it. You're the beneficiary and you're the trustee. As far as the court's concerned, that's your asset. So it's as reachable by your creditors as it is by you. So there's no asset protection for the grantor of a revocable living trust.
Yes.
Yeah. So now an irrevocable living trust does protect assets. So let's say you're the grantor. So I'm going to talk about three roles in a trust, and this is in any trust. You've got the grantor, that's the person who puts property into it.
That's right.
You got the trustee, that's the person who's in charge of it and makes distributions. So I'm speaking in general terms. And then you have the beneficiary, that's the person that benefits from it. Okay. Right. In a revocable living trust, the same individual is or the same married couple is the grantor, the beneficiary, and the trustee.
Right.
No asset protection. Now, an irrevocable trust is where, let's say I have this property I want to give to my kid. So I'm going to gift it in an irrevocable trust. So it's basically a gift. And now I'm the grantor. I put the property in there. I'm the trustee. I'm in charge of it, but my kid is the beneficiary. And so that will provide some asset protection. And there are various types of irrevocable trust that you can do in California that will provide a level of asset protection. But again, you're giving it away. So whatever asset you put in there, you're going to file a gift tax return. The trust is going to have its own taxpayer identification number, its own EIN. It's going to be possibly paying taxes. You kind of have to work that out. There are options, but you've given it away. The beneficial owner now, or the person who benefits from it, is the kid or whomever.
I'm going to say something because you mentioned it, and I need to warn my audience so they don't make that mistake, because I've seen it done in the past. If you do what Daniel said, you want to give your kid the house during your lifetime, do not transfer title to them. Do not put them on title during your lifetime, or they will not get a step up in basis. That is very important. I'm not an accountant. This is not legal advice. This is not accounting advice. But I see it when people are like, "Oh, I'm just going to give the house to my kids anyway because they're going to get it when I'm dead." So they transfer title, and now when the parent dies, guess what? They no longer own the house. So there's no step up in basis, which can be disastrous for tax consequences. Sorry for this segue. I can't help myself. I love the sound of my voice, and I love to talk about this.
Well, there are more adverse consequences than just that. So when you, and I see this a lot, actually, this is do-it-yourself estate planning when somebody adds a kid. Sometimes it happens because the lender needs somebody else to sign on the loan. So they add somebody. Now, I'll tell you the other disadvantages. Not only do you lose the step up in basis, which saves capital gains tax if you inherit, and the principle here, for those who might not be familiar with it, is when you receive a property because somebody died, you get your basis for calculation of capital gains tax is basically the value of the property at the time of death.
Right.
So if it's worth $2 million, you sell it for $2 million the next day, you pay zero capital gains tax. But when you gift property to somebody, let's say that person paid $1 million and now it's worth $2 million, and that person gifts it to you, well, you get carryover basis. Right. So your basis for the calculation of capital gains tax is what the giver, the person who gifted it to you, paid for it. And, maybe there were improvements that would add to that. But so if you turn around and sell it the next day, now you're paying capital gains on $1 million.
That's right.
And that tax is big. That's a big tax. Like it's a California capital gains tax, which is calculated like income tax. And then there's a federal capital gains tax, but you're pushing close to 50% of your million is going to go bye-bye to Uncle Sam and Uncle Newsom. So a lot of that money goes away. In capital gains tax. Now, the other adverse consequence is, and a lot of people don't get their heads around this, you will get reassessed. So you get a new property tax bill.
Right.
So if you want to keep the property, and let's say you add your kid to the deed, and now your kid presumptively owns 50% of the deed, but you're paying property tax, which is based on what you paid for that property in the 80s or 90s. And I have clients who've been in the same home for a long time. Now all of a sudden, you're going to get a new tax bill, which is going to be much, much higher.
Yeah, that's right.
So you will get reassessed. And, okay, now this is not a tax disadvantage, but it's an asset protection disadvantage. Let's say now your kid's on the deed to your property and your kid gets in an accident. Well, guess what? Now the kid's portion of that property could be reached by his potential creditors. Mm-hmm. So you're also opening up your home to liability. And you've made a gift. So you really need to sign a gift. You need to file a gift tax return. I mean, that's the least of your problems, but all those other tax issues and the creditor issues are huge. So the moral to the story is do not do it-yourself estate planning or whatever by adding a kid to the deed of your house.
That's right.
Definitely Absolutely. Not in California. Definitely not in California, but really probably you should talk to an expert anywhere before you do that.
Yeah, absolutely. And the fact that I didn't even think about the trigger of the reassessment, you're correct. I mean, we see this over and over again. A lot of people pay, who inherit home from their parents maybe paid $250,000 for the home, which today it's worth like $2 million. That's what's happening in these markets. And sometimes more. And it's crazy, when they have the estate planning in place, it really makes a big difference. So thank you for talking about that. Is there anything more about asset protection you want to say?
Oh, just try and stop me. Let's talk some more about asset protection. So one of the things that everybody can take advantage of is what you call statutory exemptions. So statutory exemptions, those are the things that the state law protects from most types of creditor claims. So I say most types, I mean like the shakedown lawsuits because you were just in the wrong place at the wrong time and there was an accident and you're 1% responsible, that type of thing. Or the feeler lawsuits, it's like, well, the guy who owns this building where I'm renting an apartment must be wealthy because he owns land and I don't, so I'm going to sue him. So those things, there are some things that everybody can benefit from. And what are those? The statutory exemptions. Now we spoke about one of them in Texas. So Texas, 100% of your homestead, regardless of the
homestead. That's right. Yeah,
that's the homestead protection. Now California has one too, and it went up. Now some states still have the homestead protection they had in like 1878, like Missouri. So that's the third state where I'm licensed. They're $8,000.
Oh,
yeah. Good luck. That doesn't get you. That doesn't even get you the land anymore. So they obviously haven't increased that in a long time. But not too long ago, they increased the exemption in California. It is adjusted for inflation, so it's a moving target. But as of this year, it's $742,000.
Okay.
So $742,000 of your home is protected by law from creditors. Now, let's say your home is worth $1.5 million. Well, that doesn't protect the whole thing, right? There's a lot of equity. There may be equity they can go after. Well, how do you avoid that? You encumber it. So
with a mortgage.
If you owe a $750,000 mortgage, and then you've got $742,000 in homestead exemption from creditor claims, then you actually have protected your property.
Mhm.
But let's say you don't need a mortgage and you don't want to pay a mortgage. And so, well, there's a little trick you can do. You can actually do a friendly lien. So friendly lien is where you open a company and your company files a lien against your property. Now you owe it to yourself, but for somebody who's taking a quick look at your property, it doesn't look like there's any value to go after there.
Interesting. Oh my God, you're so knowledgeable. I am. You're sharp. You're knowledgeable. That's amazing. Good
Fun
work.
stuff.
Good work. That's awesome.
Now, there are a few other exemptions, by the way. So we did mention the 401k. That's protected for everybody. That's actually not a state exemption. That's a federal protection. But then IRAs they're kind of protected, kind of not in California. In other states like Texas, 100% protected and distributions from them. In California, IRA's not so good. Always go with a 401k if you can. Others, your car. So in California, up to $7,000 in equity in one vehicle. So again, don't be overly quick to pay off your liens if you have them, because then if there's not much equity, they can't get it. And again, now compare and contrast. That's one vehicle for the household. As in Texas, it's the full price, the full value of a vehicle for each driver in the household.
Wow.
So you see, there's a big difference there.
Big difference. Big difference.
In Texas, also an unlimited number of fowl. So no matter how many chickens and ducks you have, your creditors can't get them. Your horses, your guns, things like that. California doesn't really care about those too much, but they do protect like some of your personal household property and household goods up to a certain amount. So these are exemptions everybody can take advantage of, but you kind of have to leverage them. So I do consultations with people who have been sued, and it's after you've been sued, it's too late to do the asset protection strategies. Like it's too late for a foreign asset protection trust, a domestic asset protection trust, a private retirement trust. It's too late for I'm sorry, my phone seems to be. I want to mute and minimize. There we go. Okay. After you've been sued, it's too late for the sophisticated asset protection structures, but you can make mistakes that would expose otherwise protected assets. Like you might say, "Oh, I'm going to take money out of my home now." And like, "Whoa, wait a minute! You know that equity is protected up to a certain amount." Or they might say, I have to liquidate my 401k so I can do this and that. You're like, no, wait a minute, now don't do that. So I do have that conversation with people. It's like, what's protected, what's not, what do you have to worry about, what do you not have to worry about, and when do you move to Texas?
I love it. That's very nice. Let me ask you a question. What are your thoughts on the charitable remainder trusts? I hear them, going around. People talk about in certain circles. Is there any real protection there, or is that just a big loss of control?
Well, it's basically, it's kind of an irrevocable trust. It is an irrevocable trust where you're giving things away. Most people don't do it for asset protection so much as for tax advantages.
Right.
So if you're experiencing, let's say you're experiencing a liquidity event. Let's say you have a business, you're selling it, it's worth $20 million. You're about to get hit with a huge capital gains tax. And you just need to mitigate that. And you're charitably inclined, let me add, you really have to want to be charitable for these things to work for you. So when people ask me about charitable remainder trusts, I say, do you have a favorite charity? If they're like, no, but I'd rather give it to, Uncle, the charity, some charity than to Uncle Sam and Uncle Gavin, then I'm like, well, you may not be the best candidate because there's a possibility that you won't save as much as you think you're going to save.
Right.
So that's the charitable remainder trust, though, gives you residual income. So the way it works is there's a final amount that goes to the charity after a period of years. And in the meantime, you get income. Now, that income the taxation of that income is exceedingly complex. There are like 4 layers, and so, like the return of principal is not taxed, but income is taxed, and that's going to be distributed first. So you are paying taxes on the income that you receive every year, and that income can now be seized by a creditor in California.
Interesting.
So you're not really, you're giving stuff away. You can always give stuff away to protect it. But
you might as well give it away to the creditors to begin with.
Yeah, but now let me just add though that if you give it away after you've been sued, so this is why I say that it's very limited what I can do with people after they've been sued. if you give it away after you've been sued, then that triggers what you call fraudulent transfer rules. So fraudulent transfer rules mean, oh, you knew there was a creditor, there's a potential creditor, or you had a judgment against you, and then you gifted this or you sold this for way under its real value. That's a fraudulent transfer. The court's going to unwind it and slap your hand and maybe slap your behind too while he's at it, because they're really not happy about fraudulent transfers. So you have to be super careful not to trigger those fraudulent transfer rules. Now, before you're sued, go ahead, give away whatever you want. I mean, your creditors won't be able to reach it, but don't think that you're ever going to see it again either. It's like some people say, well, I might get sued. I want to give this property to my kids. Like, okay, well, the kids still know you after the kid gets a $2 million property. You really think you're going to have a place to lay your head when you give it to your kids? I mean, have you ever read Shakespeare? King Lear, right? Remember King Lear?
Yeah.
Go ahead and give it away. Are your daughters going to take care of you? Maybe 1 out of 3, if you're lucky.
Yes, and that's why I have 4 children, 3 daughters. So, one of them is going to wipe my behind when the time comes. The chances are I have better chances than that. Look, Daniel, I would talk to you forever. Like, you are so knowledgeable. This is one of the most informative episodes we've ever done. Like, you are a powerhouse. But I got to cut it short here and go back to that guy who hasn't gotten sued yet, and he's going to contact you. He hasn't gotten sued yet, and he wants a consultation. Let's talk about I-Plan law. Let's talk about what you did, because your journey, I mean, as you said, Texas, Missouri, California, you lasted in 3 states. How do people get a hold of you? What does it look like, and who should reach out to you?
Oh, those are great questions. Okay, so you see my little tag there, I-Plan Law PC. That's my company. So my website is I-Plan Law. My email is Daniel@iPlanLaw.
Nice.
My YouTube channel is I-Plan Law. So I-Plan Law, I have the trademark.
That's awesome.
You can find me. All the I-Plan Law stuff should lead to me. I have a physical office in La Cañada, Flintridge, which is just north of Pasadena, here in Southern California. And I have, what does it look like with me? I usually have an initial consultation with the client. Then we chat about what I can do for the client. If it's too late, or if it's good time to do asset protection structures. So there are various ways that, I walk through. Let me back up. If it's an asset protection call, because I do a lot of just estate planning too, which always should include some asset protection. But if it's an asset protection call, I'm going to walk through all your assets. You really need to tell me about what you have. You need to tell me about the liabilities. You need to tell me about the family dynamics. So I've got to bring out of you where everything is, how it's held. And a lot of people have no idea. Like, they don't know the difference between an IRA and a 401k and a brokerage account. So it may be very new to you. That's fine. I was a professor in a previous life, so I'm happy to kind of walk through things with people and explain them what's on the table, what isn't. And then what can we do to protect those exposed assets? So the assets that are not protected by any exemptions, are not protected by any structures, what can we actually do to protect them? And then we'll talk about various possibilities. We'll talk about the costs, and then we'll talk about the loss of control. I really want clients to be comfortable with things before we do them, especially if it entails a loss of control. And some people don't want to lose control. I'm like, okay, that's fine. You can keep control, but as long as you have the access and the controls, your creditors can reach it. So, what are your options? So I always talk people through to be sure that they understand the consequences of whatever they want to do. Then I give them the pricing of whatever they want to do, and then they can decide to do it or not. I do a lot of things flat fee. Some very complex things. If I'm putting together, 3 dozen LLCs for you, which I'm doing for some clients now, then I'm probably going to, charge hourly, which might be better for you than the flat fee. But a lot of what I do is flat fee. Some of it is hourly. And my approach is always be sure that the client understands and is comfortable with what you're doing before executing it and implementing it.
That's awesome. Daniel, thank you so much for being on the show. It's been so good to have you. I'm gonna have you back. We're just gonna, I'm gonna have you back to do a stand-up routine. People don't know that you're multi-talented, not just sharp, but you also have a comedy. You want to leave us with a joke? Come on, leave us with a joke.
All right. So I've got this client, and she comes to me and she says, in my estate plan, I want it written that I'm going to be cremated, and my remains will be scattered on the roof of Walmart. I said, Walmart? Why in the world would you want your remains scattered on the roof of Walmart? She said, that way I know my daughters will visit me at least twice a week.
Thank you. Thank you. Everybody, thank you so much for joining us. Stay on, Daniel, so we can say our goodbyes. But for everyone else, I will see you in the next episode. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Mazzucci is a licensed real estate broker in California, DRE number 020544763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.